Can a veteran's own statement about the stressor ever be enough without more?
Yeah, absolutely. But that depends on a couple of things. One, you have to make sure that there's no official documents, quote unquote, that directly counter that. So if you say, I was in Vietnam and we cannot find any evidence you were ever stationed in Vietnam, you are not going to win on the basis of your testimony. It is true that there are people who got temporary duty orders that just don't show up. But for the most part, they're pretty good about putting things like the medals, etc., in there that would show that you'd be eligible. If they didn't, you are probably out of luck unless you can find a very sympathetic judge. But basically, otherwise, the standard they use is balance has to be at least in equipoise, meaning, if it's kind of 50-50, it should go to the veteran. And in those cases, the people at VA, but particularly I found the board judges, have the ability to just say, okay, I believe you. Like, you've made this statement, there's nothing in the record that says it's impossible, and I believe you, so I'm going to grant it.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Jackson.
Welcome to Victory Over VA. If you're a veteran struggling with the VA's disability system, or just want to make sure you're getting the benefits you've earned, you're in the right place. Don't forget to hit subscribe so you never miss an update that could change your life. I'm Christian Terrison, here with expert veterans disability attorney Alexandra Jackson of Jackson and MacNichol. Alex has helped thousands of veterans just like you to win the benefits you deserve.
I've just aged, Christian.
This podcast isn't just for veterans navigating the system, it's for their families, their friends, and anyone else who wants to stand shoulder to shoulder with those who've served. So stick around because we're here to make sure you get the support you need. Now, today's show is about a question that comes up with a lot of our clients regarding what is needed to prove PTSD. So, do I need official records to prove PTSD? So, when a veteran poses that question to you, what's your answer? Both legally and practically.
Basically, there's one, okay, I have so many smarmy comments that I could say, but I will say there is one thing that has to be official for PTSD, and that is a diagnosis. A medical doctor or practitioner, a certified medical professional must diagnose you with PTSD. You must have that record. That's not something that you can do on your own. That's not something there's a substitute for. Otherwise, PTSD is a very weird category for VA because they require either that you meet a presumption or that there is a specific incident. So the presumptions really come off of their own official records, right? That's, you were a combat veteran, that sort of stuff. There's also some MST-related things that come from what are technically VA's official records, things that are already in the service file for the veteran. But for the most part, no. Okay,
so a lot of the presumptions hinge on the presence of official records already.
Yeah, but I'd say not more so than getting veterans disability benefits does anyway. I mean, you're always trying to show that something happened either in service or you have a link to service, exposure, whatever. And you've got to be a veteran. You've got to have a DD-214. So there's always this kind of official underlying basis. But for the incident itself, there's usually other ways to prove it that don't require a DOD document, basically, Department of Defense or anything like that.
And speaking of, proving the incident, the stressor, is that, I guess, what contributes to making this such a common question for many veterans? Because
I think it's really confusing because this is the only mental health condition that VA singles out this way. If you look at any other mental health condition, VA needs some sort of occurrence in or link to the service. For most people, they start having symptoms in the service and it persists, right? And for PTSD, that's the only thing where VA has to say, or it says to veterans, okay, what incident caused this? You must be able to point at like April 8th, 1962 or something. They just don't do that with other mental health conditions. And so it gets really confusing for veterans because, you know, veterans don't have to know the difference when they apply between the different types of mental health conditions.
Right.
And so if they, and it gets even messier if you've got multiple diagnoses. So, you know, if you have a veteran who's been diagnosed with PTSD and diagnosed with anxiety, and they're both related to the service, the VA will treat those differently, even though what the claim you put in may have just been mental health condition or mental health problems, and VA will come back to you with two different standards. So I think that's very confusing to vets. And also, listen, the classic thing with our clients is that they have a problem in the service. After service, they can't afford medical care usually. They got a family they're supporting, and they just make it work, right? And then eventually, the body cannot take much more. And they go, okay, it's time for me to deal with that. They go get medical care from VA, which they may not have qualified for when they first got out of service because of the changing rules. They start seeing somebody, they get told about VA benefits, they go apply. And so for a lot of folks, there's this big distance of time. And VA wants you to pick out, I wasn't joking about the whole like April 8, 1962 thing. They want you to be able to say like, this happened, this was the name of the person involved, this was the, you know, like every detail about where you were and what happened. And they want you to like show up with an unclassified document to prove it, which is also a big issue for many people, the unclassified part.
Well, and so for a veteran who is in that situation and has, you know, no mention of mental health as a problem in their service records, can they still have a successful claim for PTSD?
Yeah, absolutely. There's a lot of things, particularly when we talk about military sexual trauma or MST, they have what they call markers. And you can use that to support other things as long as you can talk about the incident in question pretty successfully usually. So for example, you have somebody who has an incident and then even though there's not mental health treatment per se, there's other behavioral markers. So somebody with really good performances, you know, they're being rated well for conduct, they're being really rated well for how they're doing at their job, etc. And suddenly they just drop off the planet. Their scores plummet. They're getting 4s and they're getting 2s. That's a dramatic version. It may be more subtle than that, but decline in performance, requests to be transferred elsewhere, altercations or incidents with other people on base, so sort of interpersonal changes. And also, in a lot of cases, substance abuse. You get people who feel awful, can't tell anybody about it, and so start drinking or take up other substances. We've had clients where it's suddenly they're in alcohol rehab after, you know, 2 years in the service.
Well, and I think it's worth mentioning at this point, too, that a lot of those types of records aren't necessarily included in the C file that the VA generates to review when they're looking at your claim. I know that we at Jackson and MacNichol, as a matter of routine, will request the personnel records because that's where you'll find a lot of those supporting details and markers, you know, up to and including Article 15s for, you know, people whose behavior has changed dramatically after the stressor incident.
Yeah, the National Personal Records Center is absolutely invaluable. I have found what are really medical documents that should be in the claims file in the personnel records. And so it's very important to get those in a case.
Or things that were noted incidentally at the time that now, with the benefit of 30, 40 years of medical progress, we can look back and recognize as classic symptoms of a traumatic stress disorder or something like that.
Yeah, absolutely.
So for the folks who maybe don't have even those types of marker evidence, what other options are there for proving or demonstrating a stressor?
So there's a couple other sources that tend to be really good. One is friends and family who knew you at the time. I have had a number of ex-spouses, particularly ex-wives, come through my office as great witnesses who have plenty to say about the time they were married in service and why they got divorced. I have also found that records outside what is technically the military, so newspaper articles we have been able to find showing that there were accidents or deaths or car crashes. Honestly, one of the best sources is any of the .mil archives, so the Navy, etc. It's in a weird spot because they don't seem to search those for records, but this, you know the story, I'm sure. This is my favorite, but at a World War II vet who was claiming PTSD, and he said, I was on a ship that rescued survivors of a German U-boat attack, sunk the ship. We went and picked him up. It was awful. And he gave the date, and he gave the names of the ships. All this detail that I can't get from most people. And the VA said, we can't find any evidence that happened. And I said, World War II is the most documented war in history. There's no earthly way. So I Google it, right? And I'm not saying submit Wikipedia articles, because I did not do that. But check the Wikipedia sources, because I went to the Wikipedia article about the sinking of this, found all the ship names lined up, and went to the Navy's .mil site and found the pictures that the Navy had in their military archives of the ship sinking and the people being rescued. And so I went into my guy's personnel records, found the dates he was assigned to the rescue ship, highlighted them, printed out the article from the Navy's military archive site, and sent them back in and said, I think you're wrong. And to VA's credit, they turned that around extremely quickly. They're very good to the World War II guys. And so they did fix it. But it, you sit there and you're like, there's no way. There's no way that this is not documented somewhere.
Can a veteran's own statement about the stressor ever be enough without more?
Yeah, absolutely. But that depends on a couple of things. One, you have to make sure that there's no official documents, quote unquote, that directly counter that. So if you say, I was in Vietnam and we cannot find any evidence you were ever stationed in Vietnam, you are not going to win on the basis of your testimony. It is true that there are people who got temporary duty orders that just don't show up. But for the most part, they're pretty good about putting things like the medals, etc., in there that would show that you'd be eligible. If they didn't, you are probably out of luck unless you can find a very sympathetic judge. But basically, otherwise, the standard they use is balance has to be at least in equipoise, meaning if it's kind of 50-50, it should go to the veteran. And in those cases, the people at VA, but particularly I found the board judges, have the ability to just say, okay, I believe you. Like, you've made this statement, there's nothing in the record that says it's impossible, and I believe you, so I'm going to grant it.
Now, you mentioned, the National Personnel Records Center, but for a good chunk of veterans, there was the fire.
Yes, the fire.
Yes, St. Louis fire. For those veterans impacted, are PTSD claims still possible?
Yeah, of course. I mean, the other thing about VA is that the rules, in addition to if it's in the balance, it should go to the veteran, also say, gee, if we lost the records, we should kind of take them at their word. There's no evidence against it happening because we can't find any records at all. So they do theoretically have a rule in favor. I have not always found that to be super helpful because they just rely on this kind of circular logic about, well, we don't have any records to support that. It's like, yeah, you don't have any records at all, buddy, so you might as well just believe my client. But yes, as a technical matter, not required. They just have to know that you were in the service.
Gotcha.
If they can't find your DD-214 or any other service stuff, and you can't find any other service stuff to prove you were in, also a problem. But I had a guy who literally, they lost his records, and he had a picture of his, like, nuclear submarine class that included him, and he just sent it in, and that was it.
Okay. And that was enough?
Yeah.
Because I was going to ask...
They were able to basically say, okay, well, if you're here, then we're going to assume you had to have been in the service to be in this photo and yearbook thing.
They're not in the habit of letting just anybody walk up to the nuclear submarines.
No, they were not.
But I was going to ask, about a story you have of a case that where you were able to win with minimal records. You mentioned finding the Navy's own documentation supporting a veteran, but even a case where at the end of the day there was the veteran's word and little else, where you were still able to prevail. I don't know if you can think of one off the top of your head.
I can think of one that had pretty minimal support, but I can't think. I've just done so many of these guys. I've done so many PTSD cases. And I will tell you, one of the things we do sometimes to get around the specific incident, if we can't get enough evidence, is we will talk to a doctor and see if there's any other possible diagnosis that also applies, because that can lessen the standard, essentially. If you don't have to prove the one specific incident, they're way easier about giving it to the veterans. So a particular favorite is depression or other issues secondary to a physical issue. So if you've got PTSD and you can't get enough documentation, but any doctor in the world can say with a straight face that you have depression secondary to your busted left knee, I will absolutely go for depression every time. Well, I'll put forward both, but the judge will pretty much go for depression every time because it's easy. They can get you the rating. It's often the case that with mental health conditions, you can't separate the symptoms. And one of the things about how they rate mental health is that it's symptom-based, but if you can't separate the symptoms, they just gotta give it to you on the whole, to the extent they can't separate them.
Yeah, I used that strategy in a case once where, the diagnosis was PTSD, but also generalized anxiety disorder and depression, because there's so much overlap and interplay in the symptoms of each of those disorders that, to separate out and say, well, this is a generalized anxiety disorder symptom, but this one is clearly a PTSD symptom.
Virtually impossible.
Exactly. So it is, definitely a great strategy to pivot to those diagnoses that don't have the same burden
standard
of proof. Yeah. And this is another perennial issue, but how do you work with veterans who are, afraid or ashamed to talk about their trauma, even though they need to win their claims?
There's really two things we can do for that. One is we can look at what's in the record already and see, is there a written statement? Is there something from somebody else? Anything we can pull so that they don't have to repeat what they've already said. So that I could, in a memo or talking to a judge, say, Your Honor, please look at the statement dated, January 1st, 2000. And that is everything that my client wishes to say on the topic. Back in ye olden days when we went in person and the judges were sometimes also in person, one of the things that I would do is talk to the judge beforehand and say, Your Honor, this is a PTSD case, or even more likely an MST case. My client does not want to talk about this specifically. A lot of the times the judge was fine as long as I had other evidence in the record around it, so that we didn't have to talk about the incident itself, which was very generous, frankly.
Unfortunately, that's all the time we have for today, but thank you for tuning in to this episode of Victory Over VA. Please be sure to like and subscribe, and join us again next week.
Take care.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.